Okay, part 2 of August 11th, 2013. More on the ordinary and who they might be, where to look for them. We're not looking for the judicial authority. We're looking for the executive authority. Who's the chief administrator in the county? Because the county is a subdivision of the state. It's the local representative of the state government. And all of its power flows through a few offices, or really one office, and from there split into legislative, executive, and judicial. And we were talking about, let's go back up here. Development of jurisdiction in the strictest sense. The church has the right as a perfect independent society, provided with all the means of attaining its end, to decide according to the laws disputes arising concerning the internal affairs, especially as to ecclesiastic rights of its members, also to carry out its decisions, if necessary, by suitable means of compulsion, contentious, or civil jurisdiction. Okay, so we're in an ecclesiastic society right now. When you're in the state of Michigan, this is an ecclesiastic society, and it's supposed to follow the laws of God. But we're going into a court in the external forum where the attorney that's over there is going to put in some paperwork that hasn't been completed. It has errors and omissions. There's no sworn complaint from the plaintiff. The plaintiff doesn't even exist. The defendant is a fictitious entity. They're trying to enforce a unilateral contract as a bilateral contract. All sorts of things to be pointed out. The main thing is, it's the attorney has brought the case, and he is the one that is an officer of the court. So he's under the jurisdiction of the chief administrator of the county. And we want to bring our contempt of court, show cause, to the chief administrator, executive, whomever it is, president of the board, whoever the highest nut is in the county, into the internal forum, right? Because the court you're in is the external forum. We need to take it to the internal forum. That's the court that needs to see the contempt. And like I said in the last video, if you look at what it says in Michigan, if a attorney puts in paperwork that's fraudulent or errors and omissions, whatever, into a court case, it's considered indirect contempt of court. So it means that court that you're in isn't the court it needs to go to. It's indirect contempt. But you're sitting in a court. Well, it needs to go to the internal. Into the internal court. Internal forum. Right? Because it isn't a problem with the public at large. It's a problem with an officer of an ecclesiastic society that we have a problem with. It has therefore the right to admonish and warn its members, ecclesiastic or lay, who have not conformed to its laws. And we're talking penal code violations here, right? Simulating an illegal process, color of law, unlawful arrest, perjury, all the things they do. The church has first the power to judge sin. We're just going to go point the sin out to the ordinary that has executive power. This it does in the internal forum. That's where it's done at. But a sin can be at the same time externally a misdemeanor or crime when threatened with external ecclesiastic or civil punishment. The church also judges ecclesiastic crimes in the external forum by infliction of penalties, except when the wrongdoing has remained secret. So we need to take it to the church, and then they can fix it in the external forum, which is where the judge, we think of a judge, he's sitting in the external forum. We need to take it to the internal forum. In this case, it comes itself as a rule with penance, voluntarily assumed. Finally, another distinction is drawn between necessary jurisdiction and voluntary jurisdiction. The later contemplates voluntary jurisdiction on the part of those who seek in legal matters the cooperation of ecclesiastic agencies, e.g., notarially executed instruments, testaments, etc. So by the fact that it has a notary seal on it, means that they have agreed to let the church be the ecclesiastic judge. And the church is, again, the ordinary who has executive powers, chief administrator of the county. On a federal level, who's the chief administrative person within a federal district? Not judicial, not legislative, but executive. Who represents the president within a certain district of federal government? I think it may be the U.S. Marshals. Right? Somebody works for the executive branch. From the beginning of the Christian religion, the ecclesiastic judge, i.e. the bishop, decided matters of dispute that were purely religious in character. This jurisdiction of the church was recognized by civil imperial power when it became Christian. So this goes back since Constantine. Right? Purely religious, purely ecclesiastic, matters of sin. They're sinning. They're breaking the 10 Commandments. It's just don't take it to the judge, take it to the executive. As long as Christianity was not recognized by the state, it was left to the conscience of individuals whether he would conform to the decisions of the bishop or not. But when, however, Christianity had received full civil recognition by Constantine the Great, raised the former private usage to a public law. According to an imperial constitution of 321, the parties in dispute could, by mutual agreement, bring matters before the bishop even when it was already pending. And again, we've already said up here that by the fact of doing it with a notary, they've already volunteered. Right? So they've agreed to let it go before an ecclesiastic judge. Even when it was pending before a civil judge, and the latter was obliged to put into effect the decision of the bishop. So the case is already going. We're going to go to the bishop, point out the sin. The bishop's going to rule, make a judgment, send it down to the civil judge, who has the delegated power of judging by the law, and enforce his decision. A further constitution provided that at any stage of suit, any one of the parties could appeal to the bishop, even against the will of the others. There you are. Oh, and then they tried to limit it to cases in which both parties applied to him. But again, it doesn't matter. It's under a notary seal. They've already agreed. This arbitrary jurisdiction of the bishop was not recognized in the Teutonic kingdoms. In the Frankish kingdoms, purely ecclesiastic matters of dispute belonged to the jurisdiction of the bishop. Matters of faith and sin. But mixed cases in which civil interest appeared, marriage, law concerning church property, belonged to the civil courts. But again, all these things are going to be under notary seal, and therefore they can be appealed to the bishop, the chief, the executive of the county. In the course of the Middle Ages, the church succeeded in extending its jurisdiction over all matters that offered an ecclesiastic interest, such as compacts ratified with an oath. Right? So if somebody's taken an oath and they're not following their oath, well, that's an ecclesiastic offense. In addition, all civil litigation in which an element of sin was in question could be summoned before an ecclesiastic court, before the bishop. Now, again, it could be that it's the chief executive officer is actually the bishop, but the guy sitting there as the county executive, county administrator, president of the council, whomever it is that has the administrative powers, that's the first person you're taking it to, and he's going to then have to take it to the chief executive officer, being the bishop, and he's going to be the one who renders the judgment back down to the court. Also, the ecclesiastic court had jurisdiction over the affairs of ecclesiastics, monks, nuns, poor, widows, orphans, also of those persons whom the civil judge refused to give legal redress. Well, we've tried to get redress before and it hasn't worked. So you can take your appeal to this guy for a case that's happened in the past. We don't go to the appeal court as far as the judicial arm, I don't believe. Right? You're going to go to the county executive and say, this is fraud. Owing to the unsatisfactory administration of justice in the medieval world, this far-reaching civil jurisdiction of the church was beneficial. However, it eventually overlapped the natural boundaries of church and state. The result was that the ecclesiastic became too much involved in secular litigation and grew estranged from his proper calling. For these reasons, but further also for selfish ones, a reaction against the condition of affairs of England arose. Right. There's reason they wanted the church out of the way because, well, then they could commit fraud. The church wouldn't be looking. Finally, jurisdiction of matrimonial cases as far as their civil character was concerned. Okay, at the end of the long, the church lost its jurisdiction, notwithstanding the claims of the Council of Trent, in jurisdictions and matrimonial causes as far as their civil character was concerned. Not the ecclesiastic side, the civil side. In regard to ecclesiastic jurisdiction in criminal matters, the church exercised jurisdictions at first only in purely ecclesiastic offenses, breaking the Ten Commandments, and inflicted only ecclesiastic punishments, excommunication, and in the case of clerics, deposition. But with the formal recognition of the church by the state and the increased ecclesiastic penalties proportioned to increase of ecclesiastic offenses, came an appeal from the church to the secular arm for aid in enforcing the said penalties, which aid was always willfully granted. They'll do it for you. Some offenses indeed, especially deviations of the Catholic faith, were by the state made punishable in civil law. That would be the penal code, and secular penalties were attached to them. Also for certain disciplinary misdemeanors of ecclesiastics, right? Because these are officers of that court, which is part of the state. It's an ecclesiastic officer, an attorney is, within an ecclesiastic society. And that's a misdemeanor of an ecclesiastic. Conversely, the church in the Middle Ages increased the penal jurisdiction in civil domain by infliction of varied penalties, some of them purely secular in character, above all by means of something which withdrew the so-called criminous clerks from the jurisdiction of the civil courts. Okay? That's why you can't sue them in civil court. You need to go to the administrator to sue them. Then it obtained for the court held by the bishop during his diocesan visitation not only the punishment of those civil misdemeanors which involved an element of sin and consequently affected both church and state, but also punished as such purely civil offenses. They've done it all sorts of ways. The penal jurisdiction of the medieval church included therefore first merely the ecclesiastic offenses, heresy, schism, apostasy, then the merely civil offenses, finally the mixed offenses, e.g. sins of the flesh, sacrilege, blasphemy, magic, perjury, usury, etc. That's what the church has jurisdiction over. Perjury. Usury. In punishing offenses of a purely ecclesiastic character, the church disposed unreservedly of the aid of the state for the execution of the penalty. When in the aforesaid sin, the court had, by bishop during his visitation, inflicted punishment on the civil offenses of the laity. The penalty, as a rule, was enforced by the court, who accompanied the bishop and represented the civil power. The principle prevailed later that an offense already punished by a secular judge had no longer punishable by an ecclesiastic judge. Can't be tried twice for the same crime. When the sin began to disappear, both ecclesiastic and secular judges were generally held equally competent for mixed offenses. Okay, but what judge are we talking about, right? We're talking about the chief judge, I think. That go to the executive. And not, however, corporal punishment or death. If the accusation was brought before the secular judge, a civil penalty was inflicted by him, and the action of the church was limited to the imposition of a penance. The church, however, eventually lost. So, looks like it could be money and time, right? Because a penance would be go to your cell. The church, however, eventually lost by far greater part its criminal jurisdiction for the same reason which, since the end of the Middle Ages, led to the loss of most of its contentious jurisdiction, and in the same manner. However, from the 15th century on, which first arose in France, that the appeal from abuse of power by an ecclesiastic authority did much weaken the discredit ecclesiastic jurisdiction. Okay, well, what is it presently? Today, the only objects of contentious ecclesiastic jurisdiction, in which the jurisdiction, however, the state often takes part or interferes, are questions of faith, the administration of sacraments, particularly the contracting and maintenance of marriage, the holding of church services, the creation of modification of benefice, the appointment to and vacation of ecclesiastic offices. That's what the church does. And I want to be appointed to my office. The rights of beneficial ecclesiastics as such, the ecclesiastic rights and duties of patrons, rights and duties of religious, and the administration of church property. That's the ecclesiastic jurisdiction. As to the criminal jurisdiction of the church, it now inflicts on the laity only ecclesiastic penalties for solely ecclesiastic offenses. Perjury. If ever civil consequences ensure, only the civil authority can take cognizance of them. As regards ecclesiastics, the power of the church to punish their disciplinary offenses and maladministration of their office. Right? And again, these are officers of a church. Where the church and state are not separated, the state aids in investigating these offenses as well as in executing the canonically rendered decisions of the church. Right? So they took God out of the courtroom, they just put him in the executive's office. And at that level, there is no separation of church and state. Because he's there to administer church law, the ecclesiastic constitution. As the civil offenses ecclesiastic jurisdiction carries with it no secular consequences, though the church is free to punish such offenses by ecclesiastic penalties. According to something or other, those persons fall under excommunication reserved to the Pope who directly or indirectly hinder the exercise of ecclesiastic jurisdiction in the external form or in the internal form, as well as those who appeal from ecclesiastic to civil jurisdiction. Finally, every legislator or person in authority who directly or indirectly compels a judge to cite ecclesiastic persons before a civil tribunal. Okay, so what is all this saying? Those persons fall under excommunication reserved to the Pope who directly or indirectly hinder the exercise of ecclesiastic jurisdiction in the external form or in the internal form. They're going to be excommunicated. Anybody who stops this man from doing his job will be excommunicated. As well as those who appeal from the ecclesiastic to the civil jurisdiction. Right? So we're not going to appeal to the civil, we're going to appeal to the ecclesiastic. That's okay to do. Finally, every legislator or person in authority who directly or indirectly compels a judge to cite ecclesiastic persons before a civil tribunal. Well, how do we prove we're an ecclesiastic person? We're going to have them show them your birth certificate or show them your baptismal certificate, and you tell them I'm in a different jurisdiction. I'm in the Church of God. Right? Not the Church of Michigan. And now if they make you go before that civil tribunal, they can be excommunicated. All right. We looked at this before. Within civil governments, notably the southern United States, we're talking about the county ordinary, marriage licenses and adjudicating claims against an authority. And that's what we're trying to do. Against an authority. An officer of the court who's brought us there. You got to take it to the county ordinary. Ordinary power. The canon of the power to govern the church divided into the powers to make laws, enforce the laws, and judge based on the laws. A person exercising power to govern either because the person holds an office which the law grants governing power, or because someone with governing power has delegated it to that person. So like the state governor to the county executive. Ordinary power is the former, while the later is delegated. It can still be delegated to the office. The office with ordinary power could possess the governing power itself, or instead it could have ordinary power of agency, the inherent power to exercise someone else's power. Right? So this guy has the power to exercise the governor's power, then that's what he's got. The law vesting ordinary power could either be ecclesiastic or divine law. Either way, it has to do with religion. The office of a diocesan bishop possesses their ordinary power. Many officers possess ordinary power, but due to their lack of ordinary executive power are not called ordinaries. This is the whole point. Lack of ordinary executive power. We need the dude with the ordinary executive power. Chief administrator of the county. Yeah, look, I went through this one before, so I'm about done talking on that stuff. Anyways, don't know what to do with it yet exactly, right? But it's going to have something to do with taking the complaint to a different office. And the county executive in Bay County, although I'm not in that county, but it shows they have an ombudsman's office. So what's one of the things you look for? An ombudsman office at county level. Or you look for the chief administrator, county administrator, county executive, president of the board, whoever has administrative power. What else we have here? A few weeks ago, when the Pope put out his motu proprio on the jurisdiction of the Vatican City state, he was going to add some things to the law, and it looks like these are the things that they changed. And this comes off of this thing right here. Maybe. Law NIX, amendments to the Criminal Code and the Criminal Procedure Code, 11 July 2013, the Pontifical Council for the Vatican City State. The whole thing is quite interesting to read, but I haven't had time to read it all yet, so I'm just going to point out a couple things. Article 11, enslavement. The text of Article 145 of the Criminal Code is entirely replaced by the following. He who exercised the power attaching to the right of ownership over a person, or who subjects or keeps a person in a state of continuous submission, forcing her to work, to provide sexual services, to beg or to provide any other compensation that constitutes exploitation, is punished with 8 to 20 years of incarceration. And we thought this just had to do with a little bit of kiddie porn they were talking about. No. It's called slavery. He who exercises the power attaching to the right of ownership over a person. Who says they own you? I don't know. Somebody's trying to. That would be enslavement. For the purpose of this article, it only gets better. For the purpose of this article, the subsection or retention of a person, or the subjection or retention of a person in a state of submission is deemed to occur when it is committed through violence, threat, deception, abuse of power, or abusing a situation of physically or physical vulnerability or need, or through the offer or conferral of money or other benefits to he who has control over the person. And the Pope is going to enforce this internationally. It has to be it. The rapture coming up. Man, all these people are going to be missing. September 1st, 901. Boom. They've already committed their first crime. They showed up. right? Because all they're going to do is violence, threat, deception, abuse of power, abusing a situation of physical vulnerability or need, or through an offer or conferral of money or other benefits to the one who has control over the person. That's going to be called slavery. 8 to 20 years. Extortion. The foreign public official, or the official of a public international organization who, abusing his position or powers, or through the performance of or failure to perform an act appertaining to his functions in violations of the law, compel someone to give or promise an undue advantage for himself or another, is punished with 4 to 7 years of incarceration with perpetual interdiction from the public office and with a fine of no less than €20,000. That's your county clerk. Court clerk, whoever says, it's just the way we do it. If you're not following the law, you're doing it by custom. Bingo, that's called extortion. Abuse of functions. Unless it constitutes a more serious offense, the public official, the foreign public official, or the official of a public international organization who abusing... What's a public international organization? Sounds like a federal government. Who, abusing of his position or power, performs or fails to perform an act in violation of the law in order to obtain an undue advantage for himself or another, or to cause unjust harm to another, is punished with 1 to 5 years of incarceration with a temporary interdiction from public office and with a fine of not less than €5,000. The same penalty applies to the public official, foreign public official, or the official of a public international organization who, in the exercise of its functions, incites someone to violate the law or provisions of the authorities. All right? This has to do with all that frickin' paperwork like with the IRS, where really all they're charging you with is putting in a false statement. Well, a falsehood is an ecclesiastic crime. They're charging you with perjury. Not anymore, they're not going to. Perverting the course of justice. The provisions of the preceding articles apply also to he, in the course of a trial, artificially modifies the state or setting of situations or things or persons in order to deceive a judge during judicial inspection or recreation, or an expert witness during an appraisal, unless it constitutes more serious offense. Provision of the preceding article also falsely declares or testifies in sworn documents or in other legal instruments to be produced before judicial authorities with a view to deceive the judge while assessing the evidence. So maybe they're going to make the judges and the judge in the courtrooms now a little more, put them on the hook. Induction of false testimony. Unless it constitutes a more serious offense, the penalties foreseen in the offense set forth in chapter apply also to he who induces someone through the promise of an undue advantage to commit one of the offenses set forth in this chapter. When the induction is achieved through the use of physical force, threats, intimidation, the penalty is 5 to 10 years. They tend to do that to us quite often. When the offense has been investigated, it is not be committed. Penalty of investigation is reduced between a third to a half. So there's some real interesting parts in that criminal code, and this is something else I haven't really had a chance to get to finish yet, so I'm going to go into this yet. Alright, have we covered all the shit I want to talk about? Okay, well listen, I think that's it for now. Anyways, back to just to finish off with this one right here. The framers of the Constitution did not provide for local governments. Rather, they left that matter to the state. Subsequently, early state constitutions generally conceptualized county government as an arm of the state. Just remember that the county is an arm of the state What arm is it? It's the executive arm. It has a chief administrative officer, right? What's the administration? It's the executive arm. The CEO is one of the highest ranking members of an organization, managing daily operations and usually reporting directly to the chief executive officer. And it's the chief executive officer that certainly has ordinary executive power. In some companies, the CEO is also the president. Could be the president of the board. Very similar to a chief operating officer, and is not the same as a CEO, which is a more senior title. So the chief executive of the county isn't necessarily the CEO, he just works for the CEO. He reports to the CEO. Just like in a corporation, who's the president report to? To the CEO. In a municipal context, the title is usually used as an alternative to city manager, county administrator, or county executive. All right, so chief administrative officer, county administrator, county executive. United States, CEOs are public companies, must be chartered secretaries. And again, here's an example. The county executive, as the chief administrator, has influence over all departments except those headed by other elected officials. In that manner, the county executive appoints and supervises all department heads. It's the duty of the county executive to coordinate all county activities and unify the management of county affairs, enforce all orders, rules, and ordinances passed by the Board of Commissioners, and all laws enacted by the state. So we've made good arguments in the past, we've just not taken it to the right office. And in this particular case, there's an ombudsman's office included. The office of the ombudsman was established to receive, investigate, and to seek to resolve all justified citizen complaints against Bay County government. Go look at the definition of justified. Find out what it is and take your citizen's complaint, since that's what they want to call it. Right? We've seen these citizen complaints form before. I've seen them all over the place. Right? They exist. Every county's got some kind of complaint form. It's just we're taking it to the wrong office. You've got to take it to the correct office. And that correct office is the county executive, chief administrator, county administrator, county executive, city manager, could be the county manager. I don't know. See if they're the top dude in the administration. Okay, well, we'll see how the rest of the week goes, and maybe some of you can use this because I know you have things coming up. If you've got a court case going right now, you need to take your frickin' complaint to the chief or to the county executive, chief administrator, whoever it is, and point out the fact that there's errors and omissions on the paperwork, things we've talked about before, and leave it with him, and we'll see what happens then. Okay, we'll see ya.